sorry, good afternoon, in fact. So before we begin with the actual presentation, we've got a couple of polls that we're going to ask you to participate in. They should pop up on your screens momentarily, and you'll be able to click to give an answer. So the first one, have you implemented or are you considering implementing workplace testing? Yes, already implemented. Yes, we're considering it. Or no, we're not looking to implement workplace testing right now.
Okay, so I think most people have filled it in. We've got about 68, 69 people completed it.
Okay, so a
couple more seconds, yeah. Okay, I'm going to close it now.
We should see the results in a moment. There we go. So quite interesting. 21% of respondents have already implemented it. 51% are considering it, and 29% have said that they're not looking to implement workplace testing right now. So quite a mixed bag there. It will be interesting to see what you all have to say once we've gone through the presentation. Shall we have the next poll? So this poll's looking at whether or not the workplace testing arrangement should be compulsory or elective. Just a yes or no.
I think most people have filled it in now.
Okay, brilliant.
So give it a couple of seconds and I'll close the poll. Somebody's just put in the chat, is there a problem with the sound? I mean, I can hear.
A little closer if that's helpful.
Okay, I'm just going to share the results.
Okay, so again, a very mixed bag. 43% of respondents have said yes, testing should be compulsory. 57% have said no. So again, what we'll do, we'll go through the presentation, then feel free to put opinions, thoughts, questions into the chat. And then at the end, obviously, we'll have a chance for some questions and answers and some discussion. So thanks for engaging with those polls. The next slide. So before we dive into workplace testing and vaccinations, I thought it would just be helpful to spend a moment setting the scene. The government published its plan to ease the lockdown last month, and that plan's focus is on opening the economy and getting people back to work. That's obviously a very positive message, and as the country reopens, there's still going to be a need for effective control of the virus. If it's not adequately controlled, then obviously we face a continuation of the crisis and potential future lockdowns. We know from past experience that outbreaks in the workplace are a very real threat, and so employers are going to play a key role in managing the virus as the lockdown eases. Rather than creating new health and safety legislation to govern workplace environments and the response to coronavirus, the government's decided to rely on existing general health and safety duties contained primarily in the Health and Safety at Work Act and its supporting regulations to do the job. So the general duty contained in the Health and Safety at Work Act requires an employer to do all that is reasonably practicable to ensure the health, safety and well-being of their staff and others in the workplace who are affected by their undertaking. Applying that general duty to coronavirus roughly translates as a duty to reduce the risk of transmission to the lowest reasonably practicable level in the workplace. Now, there is a case to be made that these existing duties shouldn't apply to community-borne infectious diseases like coronavirus and that they were never intended to. But for public policy reasons, we think such an argument, if it were deployed in court, would probably fail. And for that reason, our view is that employers should proceed as if the duties do apply. Failure to comply with statutory duties is a criminal offence, so risk from non-compliance is high and arguably not worth taking. In any event, given that employers are likely to want to take these steps to reduce transmission, to make staff and others safe, it's in everybody's interest to put appropriate measures in place. So what does compliance look like? Well, it means every employer needs to complete and keep under review a COVID-19 risk assessment, which identifies the transmission hazards in the workplace and then employers will need to implement, so far as reasonably practicable, control measures which function to reduce the risk of transmission. Keep in mind now and throughout the presentation that references to reasonably practicable are significant, because what's reasonably practicable is narrower than what's physically possible. For every identified hazard, the employer is going to need to weigh the level of risk attaching to it against the financial and practical costs of implementing control measures to mitigate that risk. So where does workplace testing fit into this? Can we have the next slide, please? So we remain at this point at the early stages of a government-led initiative to encourage adoption of asymptomatic workplace testing by employers. The government's leading the initiative through its established National Workplace Testing Scheme, which last month opened to employers with 50 or more employees. For those with fewer than 50 employees, comparable schemes operate in certain areas. Those schemes are operated by the relevant local authority. The Department of Health and Social Care has published guidance for employers who are considering workplace testing, and the guidance states that for the present time adoption is voluntary but encouraged. So in addition to utilising the National Workplace Testing Scheme or local authority schemes that are comparable, employers are also free to implement their own private arrangements. Why does the government want to promote asymptomatic workplace testing? Well, it may seem obvious, but it's worth just clarifying that point. Data shows that 1 in 3 people who are infected with coronavirus won't show symptoms, but they're still infectious. For that reason, asymptomatic testing is hoped to identify those asymptomatic people so that they can be identified and instructed to self-isolate, taking them out of the population and thereby reducing transmission. So let's look at what workplace testing actually involves and how it's done. Can we have the next slide? So there are various types of tests available, which vary in quality, cost, speed, etc. Employers are free to choose whichever best suits their needs. The government's NWT scheme is going to exclusively utilise lateral flow tests, which are oral nasal swab tests that can be applied quickly and conveniently, and which provide results in as little as 30 minutes, which means same-day results. Data on the efficacy of those tests is somewhat variable, but the government's view that the LFTs are sufficiently accurate when other relevant factors such as the affordability, availability, and speed of results are also taken into account. Testing is being recommended at least twice weekly on the basis that the results only offer a snapshot, so you need regular testing in order for it to be effective. If an employer chooses to incorporate testing through the NWT scheme, then the employees will sign up to a centralised electronic system and they're notified of test results via electronic message. They can then notify their employer of the positive result if and when they get one and proceed to isolate. The employer can manage the process in accordance with its internal policies. Can we have the next slide? So we've touched there on what workplace testing is, and it's worth just remembering what it isn't. Workplace testing isn't, and the guidance is very clear about this, a replacement for existing coronavirus control measures. So if an employer is introducing workplace testing, it needs to do so as a complement to the existing arrangements, not in place of them. For that reason, the COVID Secure Workplace Guidelines, which I'm sure you'll all be familiar with by this point, remain, in our view, the essential standard by which employer compliance with health and safety duties is most likely to be measured. This means ensuring that staff work from home where possible is still essential, and that employees maintain social distancing, minimise face-to-face time working, etc. whilst in the workplace. You need to continue to keep up with increased cleaning, both in terms of frequency and intensity, continue to maintain and encourage good hand hygiene, and ensure adequate ventilation inside buildings and premises. Those kind of arrangements that are set out in the guidelines, they remain your primary focus, and they still need to be your first objective, regardless of testing. Next slide, please. So is the testing required? Well, that may seem like a peculiar question, given the fact that I've just said that it's voluntary and that it's described within the guidelines, within the guidance as voluntary. So certainly there's no guidelines or legislation that explicitly require testing. And the obvious answer to this question is therefore no. On that basis, we take the view that unless the voluntary status of workplace testing is changed, or until it's changed, it's unlikely that it's going to be considered necessary by regulators, so the health and safety executive or the local authority in the relevant area. Provided an employer has done what they need to do by taking other reasonably practicable steps, such as those that are outlined in the guidelines, then it's likely that they'll have done enough to satisfy the health and safety duties insofar as they relate to coronavirus and specifically in relation to the transmission of the virus. But that notwithstanding, there is another way to look at this, and that's in reference to the statutory duty and in particular the wording of the duty. So I outlined that earlier in the talk when I explained that employers are required to do what is reasonably practicable to reduce the risk of transmission to the lowest possible level. That's how the duty is being interpreted as it applies to coronavirus, and that's the kind of language that we do see in the COVID secure guidelines. So on that basis, if we look at the wording of the statutory duty, if something is reasonably practicable and if it will further reduce the risk of transmission, then arguably the employer should deploy that control measure. So if testing will achieve that, then arguably to comply with that statutory duty, strictly, the employer ought to introduce it. So for that reason, an employer, particularly a cautious employer, might want to ask themselves those initial questions before they make a decision on workplace testing and whether to introduce it. So first, will introducing the testing further reduce the risk of transmission in the workplace? And second, is it reasonably practicable for us as an employer to implement the testing? If the answers to both are yes, then you're probably going to want to look at workplace testing further. When you're considering what's reasonably practicable, you're going to need to look at how, if you were to introduce workplace testing, you would implement it. So the DHSC guidance outlines at a high level 3 different approaches. So they're referred to as options. Option 1 is a DIY option, which basically means that the employer takes responsibility for arranging and running the workplace testing. Option 2 is for the employer to contract with an approved or a self-certified third-party provider to deliver the testing. So that would mean that the employer has certain substantial obligations, but the responsibility in relation to the testing is handed over to the third-party contractor. Both of those options can be pursued within the NWT scheme or separate from it, though in practice we would expect that most employers are going to want to participate within the scheme since it's going to make rollout much easier. And it's worth my mentioning here actually before I forget that if you sign up for the scheme, you should do so before the 31st of March, and in doing so, you will be provided with free lateral flow tests through until June. There's links at the end that you can use to access those web services. Option 3 is slightly different in that it's only available to those employers with fewer than 50 employees, and it allows employers to make use of local community testing facilities, which, if available, will be provided through your local authority. So certain areas will have this available to them, certain areas won't, and it will be on the employer to either contact the local authority or check the online resources available from the local authority to find out if the services are available and on what terms, from whereabouts they can be accessed and how they're accessed. So clearly, how the testing will be implemented is a significant factor to weigh when you're considering if it's reasonably practicable to implement it. Can we have the next slide, please? So let's talk hypotheticals now, and let's consider a situation where an employer has decided that they are going to look to introduce testing. What legal obligations do they then need to address and have in mind when they're going through that process? Well, the issues are going to be numerous and the nuances are going to vary depending on whether the employer is implementing the testing themselves or whether they're using a third-party contractor. Factors like the size of the employer are going to be significant, the logistics, etc. But there are some legal obligations that are going to apply regardless, and so those are what we're going to touch on now. First, any plan to implement testing is going to involve a decision to alter the existing health and safety arrangements. You therefore need to ensure that that decision flows from your existing COVID-19 risk assessment, or if you haven't done a risk assessment, you need to do one first. That risk assessment and the work arrangements that come from it in their totality need to remain adequate to discharge your health and safety duty in respect of coronavirus. So that's going back to the point I mentioned earlier about remembering that testing, if introduced, is in addition to and not in place of the arrangements set out in the COVID secure guidelines. An employer needs to consult their workforce on proposals for changes to health and safety arrangements before making a decision or implementing it. So involving the workforce in this process is not just a legal requirement, but it's also a good way to bring them on side early. By bringing them into the process and involving them, letting them have their voices heard, hopefully you can build support for any kind of testing regime that you're looking to implement. So it's worth doing a proper job. Health and safety duties also require that an employer with at least 5 employees write down their arrangements. And so you're going to need to document whatever process you decide on in a suitable policy. So in addition to the health and safety considerations, there are employment law issues and equality law issues. How are you going to manage non-compliance if it occurs? And what arrangements are going to govern things like self-isolation? How will it impact things like pay, holiday, or you need to make use of the furlough scheme, etc. Whether or not to make testing compulsory in particular will require consideration of these areas. Our view is that if you're going to make testing compulsory, then you need to avoid a blanket policy, because a blanket policy could risk violating equality rights. You'll also need to give careful consideration to things such as whether or not the testing constitutes a reasonable request, and how will you respond to staff who refuse? For example, if you're going to take disciplinary action, on what basis? You'll need to update your existing policies in order to reflect any changes. Testing or use of testing is also going to require that an employer process data, and processing data needs to be done in compliance with the GDPR and the Data Protection Act to be lawful. Since an employer has to be able to demonstrate how they're complying with the GDPR, the Information Commissioner's Office has recommended completing a data protection impact assessment ahead of implementing any testing. So data law requires that data is used in a lawful, fair and transparent way. Employers need to be open with staff about how the data is being used and make sure that the data processing is limited to what is necessary, that it's proportionate. So an illustrative example would be sharing information about a positive test with other employees is necessary, but sharing the name of the individual who's tested positive is not. Similarly, it would be appropriate and proportionate to share information with those who may have been exposed, but that doesn't necessarily mean that it's appropriate or proportionate to share it with the wider workforce. Because health data is special category data, there needs to be a lawful basis for processing, and it also has to be processed in a way that satisfies Article 9 of the GDPR. You need to identify both of these things in advance of any actual processing, so it should be part of your data protection impact assessment. The ICO has published guidance to assist employers looking to introduce testing, and it covers this particular point. The ICO is recommending that the lawful basis relied upon be legitimate interest, i.e. the health and safety of staff and others, and that the most likely Article 9 condition will be employment or public health. So note that consent is not being relied on at any point in relation to data protection. Consent is relevant for medical procedure, but not for data protection. The basis for your data processing has to be established, as we said, before any testing is actually undertaken. And before you undertake any testing, you need to make sure that you've shared information with your employees so they understand what data will be collected, how it will be used, how it will be stored, and who it will be shared with. If you are going through the NWT scheme, then the auto-enrolment will deal with some of these issues. And there are also resources that are made available to you for explaining these things to your workforce. So each of those 3 areas that we've just touched upon will apply to all employers in some variation, regardless of the type of testing that they're going to implement. If you're implementing testing, these are all things you're going to need to consider. If you were looking at introducing your own private arrangements for testing, so if you like a DIY approach, option 1 in the guidance, then there are going to be other additional legal matters that you're going to need to consider. We're not going to look at these here, but it is just worth highlighting some of them. So things like staff training and staff competency to administer any tests or to manage the testing process, privacy issues, heightened data protection processing considerations, consent to medical treatment, storage of tests before and after use, storage and handling of test material, medical devices regulations, and also reporting obligations. So there's a lot of additional legal considerations that come into play if you're undertaking the testing yourself. And for that reason, there are a lot of additional risks and complexities. So our very general advice would be that an employer thinking about implementing testing on a DIY basis should think very carefully about doing so. Can I have the last slide, please? So that's a whistle-stop tour through workplace testing, which I hope you found helpful. Any queries or questions, do shoot them off into the chat, and we'll pick them up as we go or at the end. I've left you here with a slide with a link to all the various guidelines and documents that I've cited during the talk. So I'd urge you all to go away and have a read of those if you haven't done so already in your own time, and hopefully you'll find them helpful. I'll pass you over to my colleague Duncan Astill now. Thank you.
Great, thanks, Sam. So moving from testing to vaccinations, and I'm going to start with an apology that I'm going to put a bit of law in front of you, but I think it's important to understand that the current coronavirus restrictions that we're all living under at the moment have all been introduced by way of delegated powers given to the Secretary of State for Health to put in place regulations under this piece of legislation, the Public Health Control of Disease Act. And there's an important provision within that Act, Section 45E, that says you cannot include within those regulations any provision requiring a person to undergo medical treatment, and medical treatment includes a vaccination. So effectively, Parliament has reserved to itself the power to make a decision on requiring people to be treated medically or given vaccinations, and hasn't effectively delegated that to the government. So it would require an Act of Parliament to introduce mandatory vaccinations in the UK. So is that likely? If we move to the next slide, please, Rebecca. Well, if we all believe Boris Johnson, don't we? So he has said categorically there will be no compulsory vaccinations. That's not the way we do things in this country. Chris Whitty considers it a professional expectation, but there have already been some debates on the floor of the House, and Elliot Colburn, Conservative MP, sought to get that reassurance from the government that there wasn't going to be no compulsory vaccination. And you'll see the quote from him there: in a modern liberal democracy, the state cannot and should not force someone to put something in their body, nor should it introduce punitive measures against those who refuse to do so. And even at the weekend, since I put these slides together, Matt Hancock has been saying, categorically, we are not going to bring in mandatory vaccinations across the board at this stage. We are not proposing to bring in mandatory vaccinations for NHS staff. But he did go on to say that Michael Gove is undertaking a review of the moral, ethical and practical questions involved in bringing in some sort of vaccine passport scheme. And that was enough for some newspaper headline writers to say that NHS staff are going to be vaccinated compulsorily. But I think given the pushback on the government, on the politicians for the 1% increase in pay being offered to NHS workers, I think it would be very brave of them to also bring in compulsory vaccination. So at the moment, despite the headlines, there doesn't appear to be any commitment from the politicians to bring in compulsory vaccination. Next slide, please. And I think that's, probably highlights really the difficulty in doing so, not just the sort of issue of, right to self-determination, but it's a long-standing requirement in the UK that any treatment, including vaccination, requires your consent. And so, to do things against your consent is reserved for very few instances, such as people detained under the Mental Health Act, etc. And there is a significant potential hurdle in the Human Rights Act and the protections that the European Convention on Human Rights gives to citizens in the UK and many other countries. And it's just sort of important to restate that leaving the European Union has in no way affected the UK's commitment to the European Convention on Human Rights, which sits outside of the EU. The ECHR is not an EU body. And we in the cooperation agreement, the UK restated its commitment to those principles. So it would seem difficult that the Human Rights Act would necessarily allow that sort of compulsory vaccination. There's also the Equality Act, which requires employers to ensure that they don't treat people differently because of protected characteristics. And I can certainly see that some people would be bringing this into their religious beliefs or philosophical beliefs, and it would be very, very difficult to justify treating people differently because of their vaccination status. Talk of sort of bonus payments to people who've had vaccinations have already caused a few column inches of comment from legal experts. So then the other thing, I've not put it actually on the slide, but as Sam mentioned, that of course the GDPR requirements of processing data around individuals who've been vaccinated needs to be considered. And it'd be interesting to hear from a data expert as to whether you can even start to inform colleagues about the vaccination status of individuals in the workplace. Could itself create some difficulties.
Duncan, did you want me to just say a couple of extra words on the Equality Act?
Yes, please.
So you mentioned religious and philosophical belief. Generally, I think the Equality Act there is a real minefield there. I think potentially there's an argument that just about every protected characteristic in some form could be engaged. I mean, in addition to religious and philosophical belief, obviously at the moment we're approaching vaccination on an age basis. So clearly there are certain people who just because of their age cannot access the vaccination at this time. Also, the vaccination, as I understand it, isn't necessarily suitable for all people. And that relates to maybe medical conditions that they have. And so you also have disability issues there. There are also potential arguments around race, also around sex in relation to whether it's safe. I don't think they've got sufficient data, as I understand it, as yet to understand whether women who are pregnant are able to take the vaccination. So it's a real minefield where the Equality Act is concerned, I think, if you're looking at mandating the vaccination. So I just wanted to add that bit in. Great,
thank you, Sarah. So if we move on to the next slide, please. You may also have seen some headlines in the papers suggesting that actually employees have an obligation under the Health and Safety at Work Act to get themselves vaccinated. I think the Telegraph particularly ran a sort of story along those lines. And I think that's very, very difficult to see that the duty that I set out on the slide there under Section 7 would really apply to someone getting a vaccine. I mean, this section is aimed at ensuring that every employee has an obligation whilst at work to take reasonable care for himself and others who may be affected by his acts or omissions at work. And the simple thing is that it's not his job to get vaccinated. It's not an act or omission at work to get vaccinated. That's something you would necessarily have to do outside of work. And really, it's just really difficult to see how that would be applied or enforced in that way. So I think having looked at the sort of legal position, it's going to be very difficult for the court to for the government to really introduce compulsory vaccination. I'm sure that there are a lot of unions encouraging people to get vaccinated, but I can't see that they would necessarily support compulsory vaccination. So what other options are available? So next slide, please, Rebecca. So nudging, that's the new word, isn't it? Well, can we nudge people into it? Well, can we go a bit further than that? First of all, with a contractual requirement. So for those of you in the working in the health sector, you'll probably be aware that certain categories of health workers already have effectively a contractual requirement to undergo immunisation for certain conditions. The most sort of obvious one that Chris Whitty referred to in his briefing last week was, surgeons having to have vaccination against hepatitis to protect patients from the risk of transmission of that disease. So it's certainly possible to have a contractual requirement in place, subject to the Equality Act considerations that Sarah mentioned earlier. There are care home groups who are actively saying they will be making requirements, they will be issuing obligations for new staff to become vaccinated. But with current staff, then I think you're going to need agreement. It's going to be very difficult to retrospectively impose that a unilateral change in conditions, and so really it doesn't give you the complete answer. But there are sort of, and sorry, just to follow up on that point, I think it's been very interesting that Saga Cruises, for example, have brought in a requirement for all of their passengers to be vaccinated if they want to go on a cruise. But they have also sort of said they won't be making it compulsory for staff to be vaccinated. And their sort of lopsided approach is a reflection of the fact that they would struggle to recruit staff who have been vaccinated. A lot of staff come from multiple different countries and jurisdictions, and it just isn't possible really to require staff to be vaccinated. So they're getting around it in a different way by making all the staff quarantine for 2 weeks on the boat before any passengers arrive. But then if we look at what's happening in the wider economy, well, pubs and restaurants and nightclubs are talking about introducing requirements. Some of you will have seen in the news this week that in the US, people who have been vaccinated are able to now interact indoors without restriction. So we could start to see a number of different areas introducing a need to prove that you've had a vaccination before you can make use of those services. And international travel is particularly the one that seems to be leading the way, with Cyprus, I think, this week saying that they would allow people to travel there from the 1st of May if they've received both of their vaccination shots. And the chief executive Qantas has sort of said, got a record of saying that vaccinations will become a necessity effectively to undertake international travel. So not only the benefits to society, but also the sort of practical restrictions on those people who have not been vaccinated could be enough to sort of turn a few people to accept the jab when they wouldn't otherwise. So it'd be really interesting to now hear from you guys as to where you stand on vaccination. So another couple of quick polls before we wrap up. So do you think vaccination should be compulsory? No. Yes for health and care workers, or yes for all workers? Coming thick and fast.
There's still a couple of people to answer. I think we'll give a couple of seconds. Yeah, it looks like most people have answered now, so I'll just publish.
So that's really interesting. So the majority of the biggest number of people, 39%, but not a majority, think that health and care workers should be vaccinated. 34% no, 27% yes, everybody should be. So pretty split range, but overall 56% are in favour of some sort of compulsory vaccination. So moving on then to the final poll, with that in mind, are you likely to introduce a vaccination requirement for new employees? If you can add that as a requirement, is that something you're likely to do?
Duncan, I think that third option was meant to be unlikely, was it? Unlikely, possibly, indefinitely.
Yeah, it was. Apologies there.
Vote likely if you mean no.
Okay, I think most people have answered now. So
great. So the results in. So only 6%, only 4 people definitely going to introduce a vaccination requirement for new employees. Or almost half, 48%, possibly going to do it. The remainder, 45%, unlikely. Or there might be 1 or 2 outliers there from the use of likely rather than unlikely. But again, we can see that it's people still working this through, still trying to work through the implications of all this. And no doubt some consultation with colleagues and employees will be required before people make a final decision on this. So that's the end of the formal presentation. I hope that's been useful. I think people can hang around. We've got an opportunity to answer a few questions if anyone's got any. And then I think there's some sort of networking afterwards.
I think there's some questions going into the chat there, Duncan.
So I see one there, Sam. I don't think you've got a view on that. The NWT scheme ends in June, so yeah. Would that make it then no longer reasonably practicable?
Sorry, I was struggling to click my mute button for some reason. So my understanding isn't necessarily that the scheme will definitely end in June. It's just that the free lateral flow tests will be provided up until June. But certainly, if there were a change in the way that the NWT scheme were operating, and it were to impact on your ability to implement testing, then clearly it may have an effect on whether or not it's still reasonably practicable for you to continue providing it, and you might want to review your arrangements closer to that time.
So reasonably practicable, if we just talk about that for a moment, is really placing the time, trouble and cost on one side against the the potential risk that you're averting on the other. So hopefully by then we'll have a pretty low levels of virus circulating. So thought on the less likely it is that an employee themselves are going to attend the workplace with the virus, the less reasonably practicable spending money on a testing system would be. But I think we all have to remember that Chris Whitty in particular has made it plain that he's not expecting us to be out of the woods by the summer. The summer is probably going to be the best position, but that come the autumn and the winter, there's likely to be another surge of the virus, and so it might be something you would not necessarily want to do in the peak of summer, especially if people are still working from home where possible, but it might be something you bring in as rates rise. What else have we got? So we've got if an employee says they can't have a vaccination due to a medical issue that hasn't previously declared, are we able to request further medical information? I don't know whether there's an employment law issue there, Sarah, but I think from a health and safety point of view, because it's not mandatory, it's difficult to from a health and safety point of view, seem to say you need to know more about that if they're.
Yeah, I think so. If you're proceeding on the basis that you're not mandating it, then it's hard to take that question any further. I suppose if you can justify, if we're in a situation where you feel as an employee you can justify mandating it, and somebody said that they couldn't due to a medical condition, then you might ask them to explain that further as part of your consultation with staff. But obviously you'd be in an area where you'd be potentially at risk of of some kind of Equality Act claim, likely on the basis of disability. Just while I'm dealing with questions, I'll just pick up the cheapy one. So most liabilities associated with staff transfer on a cheapy consultation. I'm not sure that there's automatically any liability in terms of the staff not having been vaccinated, but to the extent, I'm not quite sure there, is it Anya, exactly what you're thinking of there? I mean, if it's not, again, not mandatory to have it, I'm not sure what risk you're thinking of as transferring. GP transfers liability associated with the individual employee's contracts of employment. I don't know if you want to explain where your question in any more detail, if that covers it.
Whilst we wait for a response,
I think Sarah, I think Anya's put in the chat absence records. From sick leave.
Yeah, so absence records don't automatically come across on a GP transfer, although they'll be part of general personnel records you'd expect. That wouldn't necessarily highlight anything to do with the vaccine, of course. It would highlight if somebody was having long periods of absence and whether there might be an underlying health condition. And if the previous employer had to put in place any reasonable adjustments, that should come out in the ELI information, where you have to supply information around individuals' contracts of employment and what the terms and conditions are. And that's where you would generally expect, if there've been agreed adjustments, you would know about those.
Got a question about personalised risk assessments alongside company-wide ones. So absolutely, I think personalised risk assessments are appropriate. That doesn't mean that you would need a personalised risk assessment for every single employee. I think there's a proportionate way of doing it, but certainly for those who are expected, based on evidence, to be at a higher risk. So that could include employees returning from sick leave, but I think it would depend more on whether or not those employees have certain characteristics or factors that place them at a high risk from coronavirus, whether they're returning from sick leave or not. Those would be the individuals that you would want to arrange for a personalised risk assessment for. That way you can tailor your workplace arrangements to keep them safe based on their additional levels of risk.
Shall I pick up is it pronounced Saif? Apologies if I've pronounced that incorrectly. Yes, making vaccinations a conditions of employment for new starters does, of course, still carry the same statutory risks. Where it's easier is obviously changing the contracts of employment. So you've got two issues, haven't you, in current employees' contracts of employment to introduce a condition that they would have to be vaccinated. You would have to either get consent to a change to the contract and or go through collective consultation, probably if you've got more than 20 staff, and look to dismiss and re-engage. And that would be all the contractual issues. From a statutory perspective, you're at the same risk with new starters as you are from current staff of Equality Act claims if that condition cannot be justified. It's got to be a proportionate response. So yes, you're not out of the woods, if you like, and able to do whatever you like in terms of adding conditions to new starters contracts.
So there's another one that I see it about getting people to do the testing. So obviously it has been mandatory in some areas, some health and care areas, and of course it's been difficult, as Sarah Loma says, to get staff to complete the testing. And we certainly had clients who, in the run-up to Christmas in particular, found that the take-up of testing decreased significantly because no one wanted to be forced to self-isolate over Christmas. So I see Sarah nodding. So, you know, I think it is that is something we haven't touched on too much. But you know, if you are bringing in a testing regime, you know, how are you going to deal with people who, you know, don't want to be tested, don't want to be signing up for this every 2 days, you know, twice a week? So I think, you know, I don't know about you, Sarah, but there's a, you know, that might be a situation where you're, you know, you could look at this more taking reasonable care for others, that this is more of a sort of, you know, health and safety requirement because it's something they're doing whilst at work. But I don't know, Sarah, whether you've got a view of it being a reasonable management instruction.
Yeah, I mean, in terms of, are we talking about this redeploying point, if you're going on if you're providing individuals to a third party business, and that business is sets a condition that you need to be supplying staff who are vaccinated or tested, then you may get into a situation where you could fairly look to use SOSR to terminate, but there's still going to be Equality Act issues floating around that even you as that third party provider could end up being embroiled in litigation over that. So it might be a way forward. Lisa, I think you asked that question, but still with some caution, really. I think you don't have to understand exactly where you potentially fitted into that sort of position, because it's likely that the employee is going to you know, take up the claims against you.
We had a question earlier about collecting data as to who has had the vaccine, even if you're not making it mandatory for employees to have. So I think that really is going to depend on your work arrangements. So what is your reason for wanting to know that employees have had the vaccination? If that's material in some way to your workplace arrangements, so perhaps you're going to use that information to make decisions about, you know, where people can be deployed because it's a health and safety consideration, then there may be a reason for requesting that data. But equally, if you've not got any clear reason, if it's not necessary for any lawful processing basis, then you shouldn't be collecting it. I think also it's important to consider how you're going to get employees to give you that information, because they're not under any obligation to tell you if they have or have not had the vaccination, and you may not actually be able to find out anyway. So there's a combination of factors to weigh in mind there. You know, one is, what's your reason for collecting the information in the first place? Have you got a lawful basis for processing it, and can you comply with the Article 9 conditions? So is it required for for health and safety purposes, essentially. And then also, how are you going to get staff to share that information with you?